This sixth meeting of the Senate Standing Committee on Families and Children from the 2024 regular session to order. Would ask that everyone please silence your cell phones. Madam Secretary, if you would please call the roll.
Senator Chambers Armstrong.
Here.
Senator Elkins.
Present.
Senator Girdler. Senator Mays Bledsoe.
Present.
Senator Meredith. Senator Tishner. Senator Webb. Senator Westerfield.
Here.
Senator Wise.
Here.
Vice Chair Rocky Adams.
Here.
Chairman Carroll.
Here, we have a quorum and are duly authorized to conduct business. Have two bills on the agenda today. First, Senate Bill 110, an act related to child support, and the sponsor is at the table. Senator, if you would please introduce yourself for the record, and we'll go ahead and approve the committee sub.
Senator Westerfield, 3rd Senate District.
And have a motion on the committee sub.
So moved.
Second. Have a motion and a second. All those in favor, please signify by saying aye.
Aye.
Opposed, no. Motion carries. Sub is adopted. Senator, you have the floor.
Thank you, Chairman. I appreciate it, members. The bill is very straightforward, and the sub doesn't change the substance materially. This doesn't require, but allows child support to be collected or enforced, an order enforced, starting from the moment of conception. The original language of the bill was really that straightforward and simple. After some conversations with the chairman and some others, we decided to change it so that this would allow an order to be retroactively applied, dating back 9 months from birth for any order entered within a year of the child's birth. So if there's not a child support order until the child's 8, this isn't going to apply. Even at a year and a day, this doesn't apply. It's only for orders that are in place within a year of the child's birth. I do want to disclose something, it's a realistic problem that this bill doesn't have a solution for, and I don't have a solution for. After I filed the bill, I did hear from the County Attorneys Association. As much as I thought I knew about what county attorneys are doing with regard to child support, I learned a great deal from that conversation with 3 of those top professionals in the state for whom I have the utmost respect. But they talked about how their child support enforcement is entirely funded by federal dollars that are reported. They've got to track their billing down to which laptop they use, which equipment they use, which staff is spending what time and what hours on that equipment. They've got to report all that. And if any of that doesn't meet the standards or the requirements of the federal government funding that they rely on, they don't get reimbursed. They don't get to have that paid for, that enforcement work that they do. Now, they can still prosecute the charges. That's a separate thing. Prosecuting someone for the criminal act, we've made it criminal to be non-support, to commit the offense of non-support or flagrant non-support, a misdemeanor and a felony respectively. But the enforcement work of going after and collecting that child support arrearage is covered by federal funds. This would not be covered. The federal guidelines that they have to comply with are pretty strict, and I don't like them, but it says that it only counts and you can only collect once the child is born. So anything that might be covered from before the child is actually born, this office would have to do on their own. And as I spoke with one of the county attorneys yesterday, they couldn't use any of the same resources. Literally, and I asked, what does that mean? They said that the computer we use for collection and enforcement for a 2-year-old, they can't use that same machine if it's grant paid for. They can't use that same staff time. So there would be some expense for county attorneys that are doing this. On the other side of that argument, though, the flip side of that is I'm not sure how many of the cases are going to be able to show or whether or not I don't know how many orders are in place within a year of that child's birth. There is some number. I don't know what that number is. But at the end of the day, I'm willing to support it even not having that information because that child is a human life. And the support obligation begins as soon as that life begins. And I think we ought to be able to go after that. I'd be okay with an appropriation to county attorneys to cover the expenses that they have. This bill doesn't make it, but I'd be happy to support it if we had the wherewithal to do it. But I wanted to disclose that since I've had that conversation with the county attorneys, to make sure you all were aware of that same problem.
Do we have any questions? I had a conversation with the lobbyist yesterday, and there seemed to be some uncertainty about that this is kind of uncharted waters. If we do this, as to whether or not the retroactivity of this would prevent them from receiving any funding, since all of these activities are taking place after the child's birth. Are the county attorneys that you spoke with pretty adamant that it's not going to be covered, or are we just not going to know for a while?
So, no, they're pretty adamant that. So I want to break up what you asked into two questions. I don't know that there's a concern about retroactivity. There is a concern, and as I've just explained, they are fairly certain that they won't be able to collect or enforce for that 9 months prior to birth. They were very clear and certain that if they did that, they couldn't use the same resources that they would use after the child's born.
Senator Elkins, you have a question, sir?
I do. Thank you, Mr. Chair. Senator Westerfield, I really like what you're trying to do with the bill. I know that the county attorneys operate, particularly on child support, on a shoestring budget. And you are correct, right down to the laptops that they use. They have to document all of that. Do you have any idea how much this would cost?
I do not.
Follow up. I'm just not sure that with the budget they operate on, they can do it without us helping them with the funds. I like the thought of the bill. I just don't know how we get there and get it paid for.
I certainly can't. Thank you, Senator, for the question. I agree with you. I certainly can't speak to the budget any more than any one of us could individually, since it's a collectively drawn up document. And as a W name in the Senate, not on A&R, I'm one of the last people that gets to see it and vote on it anyway. But I know that the House budget did plus up prosecutors' budgets quite a bit, and some of that is for personnel. And I'm sure the prosecutors don't want me telling them that they can use this for that. But it's worth us asking the prosecutors or AOC if somebody can tell us, and I don't know if they have this data or not, when those orders typically, or even if they have a number of how many orders were entered within a year of a child's birth. I don't know how many there are. I don't expect that's a big number. It could be a huge number, and I could be just totally wrong. But again, we're only talking about the enforcement of the 9 months, not everything after birth. It's just that 9 months. So even if it was a huge number, we're talking about 9 months. And that's assuming there's an order within the first year of birth. That's assuming parent that has failed under that order has failed within those 9 months and has started developing an arrearage within those 9 months that's collectible, or that would otherwise be collectible. And then this bill would ask them to do that on their own dime. One of the county attorneys I spoke with yesterday mentioned that Georgia has passed a similar bill. I have not read it. I have not looked at what they've done. My sense, based on what limited information I have, is that they've done the same thing that I've talked about doing here. It's making sure the prosecutors do that using resources not related to what they're using for typical enforcement.
Thank you, Mr. Chair.
I like this bill. I mean, you look at where we are, those of us who are pro-life in this room, that's where life starts, and that's where that obligation to take care of that child should begin. And I think it's a fundamental fairness issue that we do this. Any other questions?
I find it frustrating that the federal government has that rule that ties our hands and makes it more complicated.
Yeah, maybe someday that'll be changed.
Maybe.
I would entertain a motion on the bill.
So moved.
Have a motion. Second. Madam Secretary, please call the roll.
Senator Rocky Adams. Aye. Senator Chambers Armstrong.
Can I explain my vote, Mr. Chairman?
Please proceed.
I'm going to vote yes for this bill today. I started my career as a legal aid attorney working in rural Kentucky and helped a lot of low-income single moms with child support, and I believe that this bill is going to help a lot of folks who have given birth. I'm really grateful for the sub. I had concerns that the prior version created an in utero cause of action that could have had some downstream consequences, like what we saw in Alabama. This version addresses my concerns, and that's because the cause of action only arises after there has been a healthy birth of a child, and then you can retroactively seek support. I do still have some concerns about putting this in child support. I would love to see this term something like maternity care. I worry about this being a stepping stone to things like in utero visitation and sort of the downstream consequences that could arise from putting it in this section of the law, and also the logistical issues that you raised. And so I'm going to be watching these issues, and I reserve the right to change my vote on the floor if any other concerns arise. But thank you.
Senator Elkins,
I vote aye.
Senator Girdler, Senator Mays Bledsoe, Senator Meredith, Senator Tishner, Senator Webb, Senator Westerfield,
Aye.
Senator Wise, Chairman Carroll.
Aye. On a vote of 9-0, bill passes. Senate Bill 110 as amended by PSS 1 passes with favorable expression. Congratulations, Senator.
Thank you, members.
I'm going to yield the chair to Vice Chair Rocky Adams.
All right, as the chairman makes his way to the table to present Senate Bill 203. Do you have any guests? I see them coming forward. Please introduce yourself for the record and proceed.
Danny Carroll, State Senator from the 2nd District.
Sarah Vanover, Policy and Research Director with Kentucky Youth Advocates.
Charles All, Executive Director, Kentucky Chamber Center for Policy and Research.
Madam Chair, it's an honor to be back today to present Senate Bill 203. If you all remember last week, we went over the details of the bill. So today my plan is to basically adopt the committee sub, which I'll make a motion on that now.
All right. I have a motion and a second to adopt the sub. All those in favor signify by saying aye. Any opposed? All right, the sub is before us.
Okay. Madam Chair, what I plan to do is just go over what the committee sub actually does, the changes that it makes, and then if we have questions, we'll be happy to answer those questions. First of all, in Section 2 of the bill, it changes the definition of eligible program of study, and this has to do with the associate's degree in interdisciplinary early childhood education entrepreneurship. And it just cleans up the language KHEAA requested to clarify that specifically that degree would be included in the Work Ready scholarship. And I want to remind everyone on Work Ready, those are last dollars that go into this. So any other scholarships or any other funding must be sought first, and the Work Ready are last dollars that would go in towards this degree. On Section 4, this is in Chapter 199, creates a definition, establish the innovations of early innovations in early childhood education delivery fund and the requirements and operation of the fund for the purpose of offering grants to applicants for the purpose of increasing availability of early childhood education services in the Commonwealth. The committee sub changes this section to update the definition of eligible applicant and eligible project to specify on the participation of existing public school programs, to specify the limits on the participation of existing public school programs, and it raises the maximum award allowed to $150,000 from $100,000, and it also changes the requirement. They must be offering services within 1 year, and they must operate for a period of 3 years, and if they fail to do that, they have to pay the grant funding back. In Section 5, and this is in relation to the Foundations for Early Learning Fund. In this particular section, the committee sub changes it to specify that the Foundations for Early Learning Fund's grants shall be issued on a semi-annually basis. In the original draft, we had that annually. We changed that to semi-annually. In Section 6, this has to do with the Early Childhood Education Provider Fund, and this has to do with the family ECE homes. And basically, this sets the limit on these grants, the startup grants, at $5,000 per loan, or per grant, I'm sorry. And then on Section 7, and this establishes the Early Childhood Education Provider Startup Fund, and these are for the traditional centers. This committee sub changes the section to specify that this fund is available to new and certain existing providers. And with existing providers, these would be those existing centers that basically expand their services, build a new building, add on to their current facility, and this would add them. And it also sets the limit at $150,000 for each as a ceiling for each particular grant on that. And again, they have to be open within 1 year, and they have to offer services for at least 36 months. And finally, on Section 9, this is related to the child care assistance. The committee sub changes the section. It establishes a transition period when individuals are no longer eligible to 3 months. And so that means if they go above 85% of the state median income, then they have 3 months to adjust to that, and then they would lose that benefit. It was at 6 months. It's currently at 6 months. This would move that down to 3 months, and this is a requirement from the federal government that we do this. And that is what the committee sub does. And Madam Chair, if I might, I got an email this morning that kind of brings home exactly what all of this is about. And this was an email from a young father who just had his first child. And the message is this: I saw you on KET last night and appreciate your common sense understanding of child care issues across the state. My wife and I recently had our first child, and it is ridiculous, in capital letters, how difficult it is to find affordable care, even in a populated area like Jefferson County. We are on the waiting list for 4 daycares, all with a non-refundable fee, and still don't have firmed up care we can count on from when my wife could return to work in August. Please keep your work on this issue. Anything that could be accomplished is appreciated by families and providers. That's what we're facing. And as I said last week, we as a state can decide to fall into the pit that the other states are falling in, or we can stand up and set the example for the rest of this country to follow. We can stand up for our kids. We can show the importance that they are. We can give them the proper education that they need. We start looking at education at birth, and we invest in these youngest students. We can invest in our economy to make sure that families like this are able to go back to work to meet our workforce needs, that we can attract business and industry to this Commonwealth. So many different factors, so many different segments of our society are affected by this. And Madam Chair, if I thought for a minute that this bill, if there were child care providers out there and it was common in the industry that they were making loads of money and they were getting wealthy off of this, I wouldn't be here today. I've lived this for the last 14 years, and I know the struggles that they go through because I know the frustration that I see every month when I look at the financials from my organization. And every month, without fail, we lose money in early childhood education every month. And if it weren't for the other programs that we offer, our doors would be closed, and that would be 110 kids without services. And that's common across this entire state with these facilities. These facilities, these centers, these proprietors, they're not making money. They're not getting wealthy off of this. So what are we going to do? We have a decision to make. And Madam Chair, I'll leave it at that and would open the floor up to any questions.
We do have a question. First up is Senator Meredith.
Thank you, Madam Chair, and thank you, Senator Carroll, for bringing this bill. This is a heavy, heavy, heavy lift, and I commend you for stepping into this arena. We do have a crisis at hand, and I'm not sure that this bill is a solution to all of our problems, but I commend you for at least making the effort to be innovative in doing some new things and trying to address it. I'm sure this is going to be a topic for discussion for the next, possibly the next decade, is the right path we've going forward. But again, I think this is a Herculean effort on your part, and I commend you for it. I think there's still a lot of work that's got to be done in this arena, but I appreciate your effort. Thank you.
Thank you. And Madam Chair, I want to make clear that all these funding streams that we're looking at with these grant funds, these are funds that will roll over from year to year. So they will either be spent on expanding early childhood education or they roll over. So it's investments that will be ongoing. And as the years go by and we're able to gather more data and we're able to determine which programs are most effective, we'll be able to take a more targeted approach to make sure that we're succeeding and we're growing these providers throughout the state, whether that be providers in a church, centers, nonprofits, for-profit, the family ECE homes, and ideas that we haven't even thought up yet. Those things will be happening in this Commonwealth, and the funding is set up in such a way that it's going to be used for that. It's not going to just go away at the end of the fiscal year. It will roll over each year in a restricted fund.
Senator Tishner?
Thank you, Madam Chair. Senator Carroll, I thank you for the work you've done. This is a huge project, and I totally understand your passion for the issue, considering your experience in this arena. One of the things I can't get a handle on is we keep talking about childhood education and scholarships coming through KHEAA, a program being set up through KCTCS. Why are we hearing this in this committee, and why is this not under the Department of Education?
Simply because early childhood education is under the Cabinet of Health and Family Services.
So I guess I worry about, we have a school choice issue coming up, and one of the reasons we keep getting hung up on that is because state dollars are going to private educational institutes. A lot of debate about that, if state dollars can go that way as far as the way our Constitution's written. This would be, if this is truly curriculum where we're teaching kids and educating kids on a younger level, how will we get past that same constitutional issue that other school choice educational bills in the past have been hung up on?
We have been doing this for multiple years, where we've had the All-Stars, previously Stars program in place where there was a curriculum taught. And I honestly can't answer as far as how that relates with K through 12 education. Yeah, please.
One thing that I can say when it comes to child care funding is that with our federal dollars that come through the Child Care and Development Block Grant, there are a lot of different child care programs that you can choose, many of which in Kentucky are faith-based child care programs because churches are empty during the week, and many of them use this as outreach to their community. Many of them child care programs may partner with because they need a space that is already available, and we don't want to build new centers when buildings are empty. What we know about the requirements on federal funding and why that it is allowed to go to these private entities is with the CCAP program, the funding goes to the family. It is awarded to the family, and then the family may select which program they would like to enroll their child in. So if it's faith-based, if it's nonprofit, there are no restrictions on that as the family is the awardee, and that aligns with constitutional allowance on those funds based on what the family selects. Now, it does align with a lot of the things that Kentucky appreciates about school choice. And one of the things about childcare, when you're selecting a childcare program, is you're looking for whether it is full day or half day. You're looking for whether it supports children with disabilities, whether there is more than one language spoken in the childcare program, what type of curriculum and what star level the program is rated at. But the biggest consideration when we talk about that funding, as far as legal limitations and what is allowed, is that the funding is awarded to the family for CCAP and then it passes that way. Now, as far as one-time awards to help set up programs, things of that nature, that is devoted to construction, renovation, setup fees, and it is not devoted to long-term standards that would be implemented by the program. So again, we do not see contradictions in state and federal law that way.
All right, seeing no further questions for this panel, I do have one person that is signed up to speak on this bill. It's Ann Thompson. If she would like to make her way to the desk, please introduce yourself for the record and proceed.
Hi, my name is Ann Thompson. I live in the district of Senator Tishner, but I'm here to represent the League of Women Voters from Kentucky. This bill is important because early childhood education is essential and development for children. A forward-looking state will address the needs of these children. The League of Women Voters supports quality child care and early childhood education programs provided by certified teachers. A mixed delivery system is needed. Licensed child care centers serving low-income families is ideal. A full-day, year-round parent-provided transportation. First, state funding is needed to keep these centers open, and then startup funds will be needed to hire ECE teachers for 3- and 4-year-olds. Centers will be reimbursed for these children in the same way as public schools. We appreciate all your work on this bill, and League of Women Voters from Kentucky fully support the Senate Bill 203. We hope it gets out of here. Thank you for your work.
Thank you for your testimony. Any further questions?
Madam Chair,
Yes.
I would like to respond just briefly to Senator Tishner's comments. And, you know, we're not looking for a day, and we will have public pre-K programs, and we support that going forward. It's going to take all the delivery models that we have to be able to fill the need that we have. And so we're not really wanting to move this to KDE as part of the school system. I want it to stay where it is because there are so many different factors that we need to look at other than education. But it is very much a school choice issue for our youngest students. And as a caucus, we support that very much. These are basically small charter schools for our youngest students. So I think it's very fitting in what we believe as a caucus in what we see moving forward. And the unique thing about all of this is we have legislators from both parties that agree with this. And we have numerous advocates that are on board with this legislation. The final dollar amount is yet to be determined. And I want to make it clear, because I've gotten a couple questions from legislators on this. It was not my choice to leave the financial component off this bill. This was something that our leadership asked to do, and it's something we will have as a separate discussion. And that discussion will be had. So I would ask that you look at the policy itself, and we will make the financial decision at a later date. Thank you, Madam Chair.
Any other questions from committee members? All right, seeing none, I think a motion is in order on Senate Bill 203 as amended by PSS 1. I have a motion and a second. Secretary, please call the roll.
Senator Rocky Adams.
Aye.
Senator Chambers Armstrong. Aye. Senator Elkins.
Aye.
Senator Girdler. Senator Mays Bledsoe.
May I explain my vote? Thank you. Thank you, Chairman, for your work. And I think it's important we stop and say, we've been studying this for a year in task forces and conversations, and you have spent yourself hours talking with constituents and stakeholders. And there are 100 ways to put this together. We talk about child care assistance and intervention, early childhood intervention. There are a lot of ways we could say, here's my ideal, or here's the best way I think we should move forward. And so I think what you've done is provide us a framework to continue the conversation, and that's what we need to keep in front of us as we move forward. Because it is our conversation, it's a caucus conversation, it's in a House conversation. And as we move forward, the important part is to put the child care and the kids in front. And I think we're doing that with this conversation, and I'm proud to support it. Aye.
Senator Meredith.
Explain my vote, please. I vote aye, and I never want to disagree with Senator Mays Bledsoe, but I think there's 1,000 different ways to put this thing together, and we could really get caught up in paralysis by analysis. This is a great first effort. I'm sure there'll be changes in the future, but I think the worst thing that could possibly happen for our Commonwealth is to do nothing. So I commend you for your effort. Thank you.
Senator Tishner.
I'm going to vote no, and I'd like to explain my vote, please.
Please proceed.
I have a lot of different problems with this bill, and I don't think this committee would allow for the amount of time of questions that I have. And so I look forward to having more conversations with you about that, Senator Carroll. I do think we're going to come up with so much of this being educational. I'm very supportive of school choice. I think it's going to get held up in that way as we move forward if it does not. If we're promoting an educational bill and funding is going towards to follow the student, and right now we've just been hung up on that with other legislation for school choice. I do hope we open up the door in a constitutional amendment, but we don't know where that will end up. So I'm going to vote no for that reason today. Thank you.
Senator Webb. Senator Westerfield. Aye. Senator Wise.
Aye.
Chairman Carroll.
Aye.
Thank you. The vote is 9-1, and Senate Bill 203 amended by PSS 1 passes favorably. Before I entertain a motion to adjourn, do I have anyone on the committee that would like to register a vote? Senator Webb?
I would, Madam Chair. I appreciate that. I'm on Zoom court as we speak, and it's been a balancing act today. I'd like to record a vote, an aye vote on Senate Bill 110.
Thank you. That's noted. Do I have a motion to adjourn? All right, we are adjourned.
Take the comment.